If you've been named as an executor, or personal representative as Florida calls it, you might feel honored, but also a little overwhelmed. It's a profound gesture of trust, but it's also a critical legal role you're asked to fill, often for the first time, while also navigating your own grief. And for good reason. Executors carry a huge responsibility. You are now a fiduciary, legally obligated to act in the best interests of the estate and its beneficiaries. This means your actions are under a microscope, and mistakes can be costly and even create personal liability. You're expected to manage an estate, follow court rules, notify creditors, communicate with heirs, and handle financial accounts, all while dealing with grief. It's a demanding juggling act of finance, law, and delicate family dynamics, and the sheer volume of tasks can feel like a second job. Here's the truth. Most probate delays and disputes in Florida don't come from complicated laws. They come from a handful of common, avoidable mistakes that well-intentioned executors make. The power to prevent these problems is often in your hands, not buried in complex legal texts. That's why today on Clear Probate, we're breaking down the 7 most common executor missteps for 2025. We're not just pointing out the problems, we're giving you the clear, actionable strategies to avoid them, saving you time, money, and stress. By the end of this video, you'll feel more confident about what not to do. You'll have a clear roadmap to keeping probate on track, protecting assets, and preserving family harmony. This knowledge will empower you to honor your loved one's trust by ensuring the process is smooth and swift. Executor mistakes don't just cause stress, they cost time and money. Delays add months. A single missed filing can push probate back 90 days or more. Heirs get frustrated. Lack of communication or errors can create disputes. Courts intervene, judges may issue orders or even remove executors. Executors can be personally liable. If estate funds are mismanaged, the executor may have to repay them. If you were an executor, what would worry you more? Handling the legal paperwork or managing family expectations? Drop your answer below. One of the most common mistakes is simply waiting too long to start probate. In the wake of a loss, it's easy to feel overwhelmed and procrastinate. However, Florida's probate system runs on strict deadlines, and any delay can cause significant complications for the estate and its beneficiaries. The process begins with filing a petition for administration to formally open the probate case with the court. Once appointed, you have only 60 days to file a comprehensive inventory, detailing every asset the decedent owned. And within 30 days of receiving your letters of administration, you must publish a notice to creditors, which starts the clock for claims. Delaying these filings creates a domino effect. It postpones the creditor claim period, which holds up the final distribution of assets to the heirs, prolonging their wait. The court can also impose financial penalties, or even remove you as the personal representative for failing to meet your obligations. In a recent Tampa case, an executor waited nearly 3 months to file the inventory. The judge issued an order demanding a formal explanation, which delayed the entire probate process by an additional 4 months, increasing stress and legal costs for the family. How do you avoid this? Be proactive. Immediately create a calendar with all statutory deadlines. Don't just aim to meet them, aim to file everything early. This simple discipline builds in a buffer for unexpected issues and shows your diligence to the court. Executors must publish and send notice to creditors. If they don't, creditors can argue later they weren't given a chance to file. This mistake extends probate by months, creates liability for the executor if debts go unpaid, delays distributions to heirs. In Miami, an executor skipped sending notice to a hospital that treated the deceased. Months later, the hospital filed a late claim, and the court allowed it. The estate had to pause distributions and pay the bill, delaying closure. How to avoid it? Work with an attorney to identify all known creditors and publish notice promptly. Misstep number 3 is poor communication with heirs. Executors have a fiduciary duty to the beneficiaries, meaning they must act in their best interest. A huge part of that is keeping them informed. Transparency isn't just a courtesy, it's the foundation of a smooth process that builds trust and prevents costly misunderstandings from the very beginning. When heirs are left in the dark, suspicion and distrust fester. This uncertainty often escalates into formal objections filed with the court, leading to tense legal disputes. The inevitable result is skyrocketing legal costs that diminish the very inheritance everyone is waiting for. Take a real case from Orlando. An executor sold the family home without updating the other siblings. The secrecy backfired. Fearing the house was undersold, the siblings filed a lawsuit. While the sale was proven fair, the legal fight delayed the estate's closing by 6 months and cost thousands in unnecessary fees. The solution is proactive communication. Send regular updates, even a short monthly email outlining progress and explaining any delays. This simple act prevents major blow-ups and shows you're managing the estate responsibly. So, if you were an heir, what would matter more? Frequent updates, or just getting your inheritance quickly? Comment below. Executors must safeguard estate assets. Common mishandling includes not securing vacant homes, failing to maintain insurance, neglecting upkeep, taxes, utilities, mortgage, selling assets without approval. In Sarasota, an executor let a vacant home go uninsured. A storm caused roof damage, leaving the estate with a $20,000 repair bill not covered by insurance. The executor was held responsible. How to avoid it? Treat estate property like your own. Secure, insure, and maintain it. This is a big one. Executors sometimes deposit estate funds into personal accounts temporarily. This is a serious mistake. Mixing funds can trigger court penalties, cause accusations of theft, make accounting nearly impossible. In Jacksonville, an executor used an estate account to pay personal bills, planning to reimburse later. The court removed them and ordered repayment. How to avoid it? Open a dedicated estate bank account immediately and keep funds separate. Executors sometimes miss hearings, fail to file reports, or ignore orders. This creates court sanctions, delayed distributions, risk of removal. Showing misstep bullets. An executor in Naples ignored a judge's order to file an accounting. The court fined them personally and appointed a substitute executor. How to avoid it? Treat probate like a job, not a side task. Respond quickly to all court notices. Probate is complex. Executors who DIY often run into trouble. Without professional help, executors risk filing errors, missed deadlines, increased disputes, longer probate timelines. In Tallahassee, an executor tried to handle probate without an attorney. They misfiled creditor notices, causing 6 months of delays and doubling costs. How to avoid it? Hire an experienced probate attorney and accountant if needed. The estate pays their fees, not the executor personally. Case 1. The overdue inventory. A Clearwater executor filed the inventory 90 days late. Result? Judge warning, 4-month delay. Case 2. The family feud. A Miami executor failed to communicate about property sales. Heirs filed objections. Result? 8-month delay. Case 3. The mixed funds. A Jacksonville executor mixed personal and estate funds. Result? Removal and personal liability. Create a timeline. Map deadlines the day you're appointed. Communicate often. Even brief updates help. Open estate account immediately. Never mix funds. Hire professionals. Attorneys and accountants keep things smooth. Stay organized. Keep a binder or digital folder of documents. Be proactive. File before deadlines, not after. Executors have one of the hardest jobs in probate, but most mistakes are preventable. Avoiding delays, communicating with heirs, safeguarding assets, and getting help when needed will keep probate on track and protect you as executor. If this video helped you, subscribe to Clear Probate and let us know your thoughts in the comments. We read everyone. Here's a question for you. Which executor misstep do you think causes the most problems? Poor communication, missed deadlines, or mixing funds? Share your answer below.